To the contrary, no. The ayes have it. Members, we come to the debate on Part 2, which is clauses 8 to 12 in Schedule 2. I call Stuart Smith.
Thank you, Madam Chair. Well, in Part 2, I want to concentrate on a supplementary order 156 in my name, which actually sets out a process, would add in new clause 11A, which would allow an insured person's private insurer may be given notice to be delivered a claim and particulars under subclause 1 by the insured person, and for any claims that are received under paragraph A is to be considered as being appointed as an agent of the Commission. This is effectively putting in what was the memorandum of understanding between EQC and the insurance companies, which was brought in for the Kaikoura earthquakes. Brought in hurriedly, worked extremely well. In fact, the claim rate was far faster in Kaikoura than it was in Christchurch, albeit that Christchurch was a more complex series of events rather than a single one. However, having said that, having under the MOU, that allowed for a claim insured just to contact their insurance company, everything else would fall into place. There are, of course, the issues of getting your claim settled, but that's always the case. However, in Christchurch, what was required was a claim to be registered with EQC, contact your insurance company, and then EQC would check your insured. Then you would go through the process where the claim was assessed, and in some cases, some claims are only now being passed on to insurance companies as being over cap. Then, once the claimant is informed that they are over cap, they then go to the back of the queue with the insurance company. An unnecessary bureaucratic step that really was pointed out by everybody. Everybody agrees it's unnecessary and not really workable. And you can understand why it was set up that way in the beginning. However, we've learnt a lot now. And some of the claims, I'm going to go through some of the issues. But first of all, I want to point out in the letter of expectations that was sent by the Minister, the Honourable Dr Megan Woods, to the Honourable Dame Annette King on the 6th of March in 2018. I'm just going to quote from that, Madam Chair. I recognise that EQC is trialling a new approach with private insurers to respond to the Kaikoura earthquakes, and I expect a detailed report on the Board's review of this pilot. Now, there has been a report that's come back and said it was a very good operation and the way it worked. And then she goes on to say, I expect EQC to work with the wider insurance industry to ensure that if another significant natural disaster event were to occur, there is a commitment to ensuring that appropriate mechanisms are put in place as a priority to ensure that claims can be resolved in an efficient and timely manner prior to any legislative change that may be made. That's good, it's got great intentions, wants to move on with the process. So why isn't it in this legislation? Well, of course, they've got a review at which Dr Webb just referred to earlier. That will come out and say exactly the same thing, that we need this in the legislation, and we'll have to wait an undetermined amount of time to have this other bill come up. But unfortunately, Mother Nature doesn't wait for bureaucratic processes. Mother Nature could throw another disaster at us, whether it be a tsunami, a major event like Edgecombe, or a Kaikoura event, or a Christchurch Wellington event, something of that nature. And then we have people scurrying around trying to come up with an MOU and move on into the process. And I think that's a totally unnecessary waste of time. So my SOP will cover that off, slips into the bill very seamlessly and achieves exactly what is needed. Interestingly, I contacted the other parties on this, and the Greens said, well, yeah, they think it's a great idea, but the Minister would like to wait for the new legislation. I got an even more glowing response from New Zealand First. They say it's a good idea, but their hands are basically tied. So I want to go through, Madam Chair, with your indulgence, The response, so I've gone through, the government came up with reasons why, and EQC, why this wouldn't not work and what the issues were, Madam Chair. Madam Chair.
Stuart Smith.
Thank you, Madam Chair. So they came up with 5 reasons that they had, or areas they had great concerns with. So that first one is that there would need to be robust audit and accountability mechanisms to manage the financial costs and risks of outsourcing claims handling. Absolutely valid response and a valid concern that EQC might have. However, all insurance companies have reinsurance, and they have the same issues they have to go through. They have to be audited and accountable to the reinsurers because they're acting as agents effectively for reinsurers. EQC also acts as agents, it has reinsurance as well. And so this would actually work in the same way it does with others. So it really just seems quite strange that that would be thrown up. Under the MOU, EQC and the Kaikoura event had an opportunity at any time by providing reasonable notice to audit, observe, test or inspect any information to ensure insurers were complied with their obligations under the MOU. So all of that's laid out there in those MOUs, and the supplementary order paper would ensure that EQC entered into those sorts of arrangements. So that is a non-issue. It's just simply spurious. And their second concern was that they would need clear agreements about the quality of service provided to EQC claimants as well as ongoing accountability arrangements. I think a lot of people in Christchurch would think that was quite ironic coming from EQC, quite frankly, but nonetheless, it is something that should be tied off in a MOU or in the contract that they would negotiate with the insurance companies. Once again, that already was covered under the MOU in the previous arrangement, so quite easily accounted for within my SOP. So I think really they are raising red flags that are not needed at all. So insurers acted as EQC's agents, as I mentioned, in accordance with the EQC Act and guidelines provided by EQC. So they work within EQC's own guidelines. So quite a spurious claim yet again. And actually, after the Kaikoura earthquake, there was a 70% customer satisfaction with insurance claims. And that's compared to 43% with the Canterbury earthquake sequence and 51% with the non-Canterbury earthquake disaster sequences. So these things, people are always unhappy with their insurance companies, but in the long run, 70% customer satisfaction is a pretty damn good number, I think. The third concern was that there are robust arrangements between EQC and private insurers for sharing relevant customer and claims data in a timely and secure way. Well, under the MOU, insurers would first obtain a privacy waiver from a customer to allow information sharing between EQC and the insurer. So that was already in place, and that insurance could also seek exemptions under Section 54 of the Privacy Act in respect of certain information sharing. So all of that was covered under an MOU. All could be arranged under my SOP. So a fine piece of legislation. Not too late, Mr. Webb. I can see he's wavering. And then the fourth point was the insurance industry has the ongoing capability and quality of preparation to manage future events, particularly large-scale events. I mean, come on. Insurance industry has a far larger standing army than EQC ever will have, and it has international links to other insurance companies around the globe. They are in a far better position to gear up for large events than EQC is. And we've seen that in the past. That's why the MOU was signed in Kaikoura, because it was recognised. So I'm simply building on that. The final point was there are appropriate and robust arrangements, either with insurers or elsewhere, to replace any loss of adaptability or flexibility in natural disaster response as a result of EQC no longer directly participating in claims handling. I mean, this is nothing more than patch protection by EQC. And the reality is, We deserve better than that. New Zealanders deserve the best service that they can get. This SOP actually will ensure that, and I implore the members on the other side of the House to see some good sense and get in behind it. Thank you.
Madam Chair.
I call Ian McKelvey.
Thank you, Madam Chair. It's